good afternoon, everyone. Thank you very much for joining us today for this closed meeting of the Animal Welfare Intergroup. Let's start with some housekeeping rules. There is no interpretation, so all those who wish to intervene are invited to speak in English. Virginie Joron has asked us to speak in French. But an English version of his intervention will be available to all. Today we have a special intergroup meeting with only members and assistants and of course the invited panelists. The reason why we have chosen not to involve a wider public is because the issue of the debate is meant to be addressed only to MEPs. So we kindly ask you not to externally communicate about this meeting. The purpose of this meeting is to alert you about an ongoing case in the European Court of Justice on the legitimacy of member states to adopt a ban on slaughter without pre-stunning. Or reversible stunning, so you wish, for the slaughter of animals in the context of religious rites. The European Court of Justice will draft its final judgment in a couple of weeks, but the publication is not expected before the beginning of next year. And upon the court's request, the Advocate General published an opinion in September, which is not acknowledging member states' power of both banning slaughter without stunning and implementing reversible stunning. Only last week, an independent opinion poll was launched indicating that 9 out of 10 European citizens want all animals to be properly stunned, even for religious reasons. And also 92% of the EU citizens that are surveyed are keen on allowing member states the right to adopt additional measures to ensure higher animal welfare standards during slaughter. But before we start this, with all of this, I would like to make a few announcements about the upcoming events and an issue where your help as MEPs is needed. Because next week, as you all know, the Parliament will finally vote in the plenary on the 3 CAP reports. On behalf of the Intergroup, I would like to call on you all to promote and support within your political groups the amendments to the CAP reports that are of direct relevance to animal welfare. And the adoption of these proposals will be of tremendous importance, as the future of CAP plays a determinant role for better animal welfare in the farming sector. And the Secretariat will send you more information about the relevant amendments for animal welfare in all 3 files, so that you can seek support for them in advance. And of course, we thank all the MEPs and assistants who have worked on these files and tried to get the best results for animals as possible. I would now like to give the floor to Maria Neuchel to give us a brief update on the 3 CAP files. Maria, the floor is yours.
Reineke Anja, I think Maria Neuchel is not yet there, so we might continue with the meeting and give her the floor maybe at the end of the meeting or at a later stage.
Okay, and let's just remind all of you that the Secretariat will send around more info about the CAP files and the animal welfare related topics. Okay, the next thing I want to mention is that on the 26th of October from 10 till 12 o'clock, Eurogroup for Animals and the Animal Welfare Intergroup will hold a webinar on animal welfare in the EU-Australia trade negotiation, and especially on the EU's role in the commercial kangaroo hunting. This event will raise the issue of animal welfare in the negotiation and will see the launch of the report Australia-EU Trade in Products Derived from Commercial Kangaroo Hunting. And I have the pleasure to host this webinar myself together with Manuela Ripa from the Greens. So I'm looking forward to seeing all of you there. Before we start, the same housekeeping rules as previous meeting to ensure a smooth running of this meeting. Please keep yourself muted while someone else is speaking. And after each presentation by our guest speakers, MEPs will have the opportunity to raise an urgent question. Please keep in mind that the main debate will take place after all of the presentation have been finished. And it will take place, I think, around the last 15 minutes of this meeting. If you want to speak or have a comment, please use the chat box, which will be managed by Reineke and Andreas, and we will come back to you later on in the debate. Okay, let's now continue with the why we are all here today, the European Court of Justice opinion on slaughter without stunning. It is an honor and my pleasure to introduce to you Professor Alberto Alemanno, who is Professor of EU Law at the École des Hautes Études Commerciales et Paris, in Paris. And he is the founder of the Good Lobby, a non-profit civic startup committed to equalizing access to power to more plural, inclusive, and democratic society. Professor Alemanno has prepared a legal analysis of the Advocate General's opinion on this case. Please, Professor, the floor is yours.
Good afternoon, everyone. Thank you for the opportunity to meet you all today and to share some reflections. It's a pleasure to have the chance to meet you all today and to engage into a conversation. Before making it more interactive, I will be discussing a few aspects of this case, in particular of the opinion, and showing why it raises some issues we are particularly concerned about. So I think the most important thing to say is to identify is what is at stake. So why this case is so important, why this opinion is so important, because this opinion might be followed by the Court of Justice. Well, we're going to try to see whether the reasoning of the Advocate General is logic enough, whether it is conducive to a good response, or whether it is rather vitiated by some errors or some factual misunderstanding that might affect his own advice to the Court of Justice, which is basically to declare illegal the Flemish legislation requiring the reversible stunning. So what is at stake in this particular case? Contrary to what has been argued by the Jewish community and the Muslim community, it is not a ban on religious slaughter. This is not what we're going to be talking about. This is not what the Flemish decree defines. What is at stake is the ability of the member states, including regions like Flanders, the Flemish government, to adopt measures that might improve the welfare of animals that are slaughtered during a religious rite. In other words, how much margin of maneuver is left to our individual member states to actually govern religious slaughter. By knowing that we have a specific regulation that defines what can or cannot be done during the killing of an animal. It's important to also contextualize this question by saying that there are already countries in Europe that have been prohibiting unstand slaughter. This is Denmark, Sweden, Slovenia, and one province of Finland. So this is already a reality. What the Flemish decree does is something that other European countries have already been doing without raising too many eyebrows from the European Commission itself as a master of the treaty. What the Belgian government did in particular, the Flemish government following the Wallonian one, is to introduce a decree that no longer authorize what we have been calling the religious exception, the non-stand of production of meat, but it rather prescribe reversible stunning. So also religious community need to stand the animal according to legislation which entered into force in 2019. No surprise, the entry into force of this decree has been heavily contested by the Jewish and Muslim communities, which have challenged this legislation before national courts. It ended up before the Constitutional Court in Belgium that, facing a dilemma, decided to refer the matter to the Court of Justice. So that's how we ended up having this case in Luxembourg today. The concern of the Jewish and Muslim community is pretty much about having assurance that the animal remains alive at the moment of slaughter. In particular, the idea that only an animal which is alive will have his blood to be pumped out by still beating heart is a major concern, while at the same time reducing its suffering. So reversible stunning might actually ensure, according to the Belgian authority, notably the Flemish government, to strike a balance between, on the one hand, religious freedom, and on the other hand, the imperative, which is also written in the treaty, to reduce animal suffering. What is the legal context? What does the regulation tell us about what member states can do? I think it's important to realize, as the opinion of the Advocate General does, both in Article 3 and Article 4.1 of this regulation on the killing of animal, that the general principle is that animals shall only be killed after stunning. So stunning is the rule. Only stunning, prior stunning, according to scientific studies, can be compromising the least animal suffering. So this is the general principle. However, this regulation, when adopted, not necessarily when proposed, there was an amendment that pushed for the inclusion of another provision, Article 44, which is generally referred as a religious exception. What this provision, which is quite enigmatic, does is to waive the application of the general principles, and in particular, the list of methods which have been considered to be authorized stunning methods in Annex 1 in the situation of religious rights. So this provision doesn't tell us much. Is a derogation, is an exception that basically seems to introduce the possibility to still allow forms of unstand slaughter under the regulation, under secondary law. However, this is not the end of the story, because the same regulation on the killing of animal, after telling us first that there is a general principle of stunning the animal, and there is a possibility for a religious exception, it also tells us that member states can introduce stricter national rules. And those stricter national rules can have to do with slaughtering and related operations, which basically means and also refers to stunning. In other words, the member states can govern the modalities of stunning further and towards one and only direction, more protection for the animal. That's what Article 26.6 tells us. So as you can see, it is quite enigmatic, the relationship between the general principle, prior stunning, the derogation waiver in Article 4.4 for religious rights, and then Article 26.6 that says you countries can go further if you want than what we have agreed in the framework of this directive. So the big question, legally speaking, is the following. Are the member states bound by this derogation when they decide to adopt stricter rules? And the answer of the Advocate General to this question is affirmative. It basically says that Article 4.4 reduces the ability of the member states to actually introduce stricter rules that might impose some forms of stunning. That's what the Advocate General says. And I can tell you the reasoning, in particular in paragraph 74, is not entirely convincing. It rather seems to be vitiated by a somehow misunderstanding of what the member states agree to be bound to when drafting this regulation. So let's read together this paragraph without becoming too legal. The paragraph says that both the recital, so the preamble of the regulation, and the legislative language of this derogation, religious exception, clearly indicate a desire to preserve the ritual slaughter of animals. The further jurisdiction granted to the member states, and this is already a problem. How can a regulation provides competences to the member states when in reality those competences are already of the member states? In other words, this is an example of partial harmonization. Member states did not agree all the single details regarding the killing of animals. They just established a floor of rules and protections that should be there, that should be considered. But as Article 26 suggests, member states can go further. However, here in this paragraph, the Advocate General seemed to suggest that here we are in a situation of full or high degree harmonization, in which the ability of the member states to adopt what he called additional rules, additional measures, would be very, very limited. The Advocate General also takes the time to tell us what member states can do. He says they could include a requirement of the presence of a qualified veterinarian. They can impose a particular training on the person conducting the particular form of slaughter. They can introduce requirements regarding the knife, the second knife, but this freedom of the member states will fall short of going up to the point of regulating stunning. But that's exactly what Article 26 says, that this is a possibility, is one of the related operations. So as you can see, there is a tension between these two provisions, and that's the reason why the case wasn't necessarily easy to be solved at the national level, and why the Constitutional Court decided to ask for help to the Court of Justice. So as I anticipated here, we have a problem in terms of interpretation of the actual legal context governing this case. Recital 28 clearly says that the member states enjoy subsidiarity when interpreting and applying Article 4.4, and it also recognized that the national rules can take into account dimensions that go beyond Regulation 199. That means that this margin of maneuver exists. The same regulation also foresees, and I think this is an essential point to the whole reasoning that we need to undertake, it says that when the member states decide to introduce stricter rules, they cannot impose those stricter rules, for instance, reversible stunning, to the products coming from other countries. In other words, the free movement of meat should always be ensured. And countries cannot extraterritorially export and ask the Germans to respect their own legislation. That's what the regulation says. And the only fact that this derogation exists, the fact that there is a limit, the only limit to the member states' ability to introduce stricter standards has been foreseen in the regulation, suggests that actually they can do it. They can actually go beyond Article 44, Article 4.4. And then we also have, and this is an important point, a situation in which the member states, when they respect secondary law, as I tried to suggest you, and they depart from the Article 4.4, they are still constrained by the treaty provisions. And one of the treaty provisions is Article 13, that clearly requires both the institutions and the member states to pursue animal welfare standards. But the final constraints for the adoption of any, let's say, national stricter rule is represented by proportionality. So to wrap it up, unlike what is stated by the opinion of the Advocate General, member states can depart from this derogation. But when they do so, they need to comply with the free movement provisions, should allow in region Flanders to accept the import of products coming from other countries without asking them to comply with the Flemish decree. This is the first requirement. But at the same time, they also have to make sure that their stricter national rule is proportional. And the question, therefore, is, can we consider reversible slaughter a proportionate measure? And the Advocate General completely skip this analysis because upstream he says that member states cannot do it. So for a question of judicial economy, he decided not to examine the proportionality. But I think it's important to do it because it tells a lot about the legality of the Belgian decree. There are two major tests under proportionality. The first one is suitability. Is the national stricter standard, in this case reversible stunning, suitable to achieve its declared goals, which is to protect animal welfare while also ensuring religious freedom? And the answer is yes. We have a lot of scientific studies, and we're going to hear more about this in the coming minutes, that prove that this is the least compromising for animal welfare method available. And we also have a geographical precedent in New Zealand, which clearly show suitability. The second prong and last prong of the test is necessity. It is not sufficient for this reversible stunning to be apt to achieve the goal. It also has to be necessary. That means that it has to be the least restrictive in relation, in this case, of religious freedom to allow this, let's say, balance to be accomplished. And here we already said this is not a ban on ritual slaughter. It's a much more proportionate, let's say, incremental, stricter rule that basically compromises the least, as we said, but also when compared to alternative methods or alternative approaches, like the one adopted by countries we mentioned, like Denmark or Slovenia, which ban the Unstand slaughter, they seem to be more proportionate because they still allow the animal to be alive after 2 minutes after performing the stunning. And it's certainly more proportionate than a requirement of irreversible stunning, like other countries have been doing. In other words, behind this Flemish decree, we see an effort epitomized by long-term public consultations in which the religious community had the possibility to inform the adoption of this measure, which have then been challenged. Final word, I would like to make you think about what we can draw from the conclusion that this reversible stunning method is proportionate when compared to alternative methods. It is so important to realize this proportionality because it shows, contrary to what has been argued by the other side, meaning Jewish and Muslim community, that this is really about upgrading our understanding of the balance we can strike between religious freedom and animal welfare. If new methods are available, in the past only for sheep, now only potentially for cattle, why should we not embrace those methods which are capable of striking a new balance between those conflicting objectives? I think this is the message that I was expecting as a legal scholar and somebody who cares about animal welfare to receive from the Advocate General, but which unfortunately I didn't receive when reading and reading again, at least 3 or 4 times, his own opinion. Thanks a lot for your attention and happy to get your reactions in the next few minutes.
Well, thank you so much, Professor Alemano, for your legal context and giving us this background of the advice and the opinion of the Advocate General of the Court of Justice. Reineke, I think we have time for 1 or 2 questions. Are there MEPs who want to take the floor?
Yes, thank you, Anja. And I heard from Petras Austrevicius from Lithuania that he would like to come in. Petras, are you there?
Yes, I am. Do you hear me?
Yes, loud and clearly.
Good. Excellent. Excellent. Thank you so much for organizing this very thoughtful exchange on such a sensitive and important issue. Thank you, Professor, for approaching us on very legal aspects and comprehensively explaining the present situation. I mean, I have two probably questions to you right now. The first one, I mean, you said that even reading 3 or 4 times the Advocate General's opinion, you didn't find the precise mentioning on this animal welfare issue. Why is that? I mean, is it kind of a trick or undecisiveness of the Advocate General, still leaving it for the court to decide, or I don't know, maybe there is a certain complication in it? And my second question to you would be, knowing that there is a derogation for mandatory pre-slaughter stunning in case of religious rites, is that derogation in fact compulsory to member states to apply? Thank you.
Professor Alemanno, could you unmute yourself? Thank you. No, you muted yourself again.
Can you hear me now? Thank
yes.
you for your questions, which are excellent. Well, let me start by saying this is not an easy case. Otherwise, we wouldn't be here today discussing it. The case would have been solved by the first instance in Belgium, or during an appeal, or that by the Constitutional Court itself. It's not an easy case because, as it is often the case, the European legislature has been constructively ambiguous in the way in which adopted the proposal, a proposal that has been amended multiple times, and which has been creating this $6 million question of what is the relationship between 4.4 and 26.6, meaning what is the relationship between the religious exception and the ability of the member states to go further. I think the bulk of the matter is really about defining what the member states agreed and by themselves to. And the Advocate General recognized this is very, how can I say, often contradictory, because on the one hand, it says this regulation is about animal welfare protection, and that's what member states decided to do. But at the same time, he has a bit his hands tied by the fact that Article 4.4 introduces such a derogation. And when interpreting this derogation, it basically says in paragraph 80, the present proceedings nevertheless, in their own way, draw attention to the weakness of the present regulatory regime. It says, well, this is not very well written. It's not very clear. If the requirement of Article 13, animal welfare, are to be treated as imposing real obligation of the member states, then it behoves the European legislature at a minimum to ensure In other words, it says it's not even for the court to decide, it's to the legislature to clarify what they meant. But when we try to interpret the rules, we see that there are major factual inconsistencies. And one of the major inconsistencies, which has been highlighted by the same Advocate General, is that today consumers might end up eating products coming from meat, from Unstand slaughter, without being aware of it. And this is certainly something that has been keeping awake the Advocate General, because he realized that this is a major limitation of the system, and a limitation that hasn't been taken into account by the legislature. So I somehow understand his uncertainty, but I also feel disappointed by the fact that he was not able to say, well, the countries, the member states didn't agree on everything. This is partial harmonization. Member states can go further. And to reply to your second question, I don't think Article 4.4 is mandatory per se. I don't think is imposing all the member states to actually make sure that ritual slaughter is entirely waived from the general principle of the regulation, which is protection of animal welfare. But again, this is the point of contention, and probably we can agree or disagree. But this, I think this is the point. What Article 4.4 says is just very, very little what the regulation says. It only says, well, if you are not following prior stunning, then you need a slaughterhouse. That's the only condition to Article 4.4, which is obviously is very minimal and is not satisfactory per se because it doesn't say much about methods. And by the way, there are many other rituals that both Muslim and Jews do follow that continue to be allowed under the Belgian and the Flemish decree by the current regulation. So this seems to suggest that the current the interpretation we are putting forward seems to provide a good compromise interpretation that can find good grounds also elsewhere.
Thank you.
Thank you. Yeah, I think this was a satisfactory answer. Thank you so much, Professor Alemanno. We will have another Q&A at the end of the meeting. One more question to you, which I think is relevant for all MEPs. Clearly, the court is independent, so MEPs don't have a political or a formal position to do anything. But what could they do at this very moment?
You're right, Reineke. The Court of Justice, being in Luxembourg, is kind of tucked away from the day-to-day policy making and is not used to be subject to influence. And that's the reason why there's an opinion of the Advocate General. He really tries to be the devil's advocate and to analyze all the arguments in order to give direction. But at the same time, members of the court, having worked there for 5 years of my life, they are human beings who read newspapers, who are in contact with people, and they are certainly subject to light forms of influence because they want to inform themselves. They're very curious and they want to understand, in particular, what scientifically is possible to do today. And I think that's where each of you can provide an input by showing and raising awareness in your constituencies, but also by informing the conversation about the possibility today to strike a new balance between religious freedom and animal welfare through new methods or methods which have been existed, but now will be extended even further and that some regulations are accepting. So I think this is the point, saying that there is a moral duty to somehow review the outcome of a new balance of conflicting interests because time have changed, we have new technical solutions, and unless we do so, we constrain ourselves to live in the past as opposed to live in the present.
Yes, thank you for that. There's another question in the chat box. Someone asked, do I understand correctly that there will be a time gap, probably until next year, until the court will make public the final opinion? If yes, why? Could you elaborate a bit on that, Professor Alemanno? I know you already mentioned that the court will start their deliberations very soon now.
Yes, I think it's important to remind everyone that we don't really know when the courts take decisions. We know when a case is lodged before the court, we know when the hearing takes place, and this was a few months ago, and then we know when the judgment comes out because it's going to be announced 15 days before the reading. But in between, everything can happen. If the judges do not agree on the first draft of the judgment, or if they disagree with the opinion, which makes things more complicated, well, there might be delays. So we are not in control of the timing. We can only speculate that based on the date of the hearing, based on the date of the public opinion, and on some informal hints we might get, it might take some time before having the judgment out. In particular, the time gap you asked me about exists because the working language of the Court of Justice is French. So the draft of the judgment will be in French, although the procedural language is obviously Flemish in this case, as far as I understand. That's the language that has been used in the referral of the case. It takes time to translate the working language into, the working language into the procedural language, which is the most important language because it's the one binding, and then into the other languages. Why? Because this case is going to become legally binding all across the union, because this will be the authentic interpretation of the relevant regulation. So it takes 6, 7, 8 weeks before having the actual deliberated judgment, so the judgment they agreed upon, to be published and translated and made it publicly available. This explains the time gap.
Thank you, Professor Alemano. And this also means that we have a very tight window before the court will make up its mind, and that also this verdict will have far-reaching consequences, not only for the countries that have already introduced stricter animal welfare measures, but also for all the countries who would be considering introducing such measures. So, Anja, I think it's time for our second keynote speaker. Over to you again to introduce our guest.
Thank you, Reineke. Well, I would like to warmly welcome our second distinguished speaker, who has addressed the intergroup several times before, Professor Donald Broom, Emeritus Professor of Animal Welfare at Cambridge University. And today he will tell us why slaughter without stunning is an issue and what alternatives there actually exist. Professor Broom, Donald, the floor is yours.
Thank you very much. While I'm sharing the screen, let me say first, thank you very much to Alberto Alemano. That was a really helpful presentation. And can you see the screen all right? Yes, thank you. Okay, so I'm having heard something about the legal aspects. I'm going to talk about the scientific information in relation to stunning and not stunning animals. And we already heard about public concern about the welfare of farm animals. And we get this result every time within the EU. Consumers are very concerned about animal welfare. And we know very well that consumers avoid products if they know about poor welfare in the animals. So the first thing to say is there is clear scientific evidence for pain and fear systems in all vertebrate animals, including fish and some invertebrate animals. These are sentient animals, and we are very well aware of that, everybody in this audience I know. And pain and fear are important aspects of suffering, poor welfare in animals, and we have a lot of scientific evidence. And actually in this particular area, we have a lot of good quality scientific papers. We have evidence about pain. This is a part of the recent Animal Welfare Indicators EU-funded study looking at how do we identify pain and other aspects of poor welfare in a number of species. And so we have a lot of information. And it is important, I think, for the general public to say that farm animals, like cattle and sheep, for example, are sensitive to pain. They are just as sensitive to pain as humans. There's sometimes an idea, well, these animals have thick skins, but actually if you watch them when a mosquito is biting them, you can see that they respond to it. So they are responding to small things. So we talk about humane treatment of animals, and humane means treating them in such a way that their welfare is good to a certain high degree, which is specified in different areas of their treatment. And it is a principle underlying the regulation, which has been referred to already, that humane killing has to be used in general. It refers to the treatment of the animals before the actual period of stunning or killing. This should not cause poor welfare. Then the actual stunning and killing procedure that needs to result, the killing procedure the stunning needs to result in instantaneous insensibility. And there's an alternative if the animal is being killed by a gas or an injectable agent, that it should be something which is not detectable by the animal until the point where it becomes insensible. At least that is the principle. And then the last part, when the animal is going to be killed, during insensibility, there is a killing method which is carried out so that the animal does not recover consciousness before death. Normally, the killing method is cutting the throat, and the animal dies from blood loss. Okay, so this is the general situation, and this is just a picture of an EFSA report, which goes into quite a lot of detail about it. So we have then, most animals are being stunned before killing, but in some countries, in fact, in many countries in the world, killing by cutting the throat without stunning is permitted. So it's halal or shikita killing. But as you've heard already, in certain countries, the stunning is always legally required, and there isn't an exception for the animals killed by halal or shikita. The present situation in many countries in the world is that, particularly during halal slaughter, that in many instances, the animals are stunned at just about the same time, within a few seconds of the time that the throat is cut. And I know that in the UK, it's about 80% of all halal killing, the animal is stunned at the same time. And so it is accepted by quite a high proportion, and I don't know what the figure is for all countries. There is also some shikita where the animal is stunned at the same time, but less than the halal. Okay, let's consider some important fundamental questions. The first one is stunning. Do the stunning procedures work? And the answer is that the legally required stunning procedures do work very well indeed. And that means that insensibility is instantaneous. And there has been a very good set of papers produced by the group at Massey University in New Zealand with Troy Gibson as the first author, a series of papers which show that this is true. This can be found out by recording from the brain, which is the electroencephalogram, or looking at evoked responses, that's electrical responses in the brain when the animal had received some stimulation, or looking at reflexes. And what Gibson found out was that when calves were stunned with a captive bolt gun, according to the regulation, which is the same one we have in the European Union, that what was seen was that total power of the EEG decreases sharply at the point of the stun. In other words, stunning is causing insensibility in the animal. So that's the first question. And then another question is, how often is it wrong? Well, we have good evidence on that. It varies a bit, but the average across the European Union is something like 0.1% with a captive bolt gun in a slaughterhouse designed to kill mammals. So about 1 in 1,000 times it doesn't work. And what happens in that case is that they always have to have an extra captive bolt gun, or if it's electrical, they have the facility to carry out the electrical stunning again. And it is generally speaking done within 10 to 15 seconds. So if they get it wrong, they do it again, and it takes 10 to 15 seconds. But that's only 1 in 1,000 animals. So in general, it is working. Okay, supposing instead of this procedure, shikita or halal is used, then the question is, does the animal suffer, and how much does the animal suffer? Well, this, I think everybody knows what is involved here, but it is a cut, a cut across the neck of the animal, severing the blood vessels. And I would say right now that when these methods were first brought in, they were very much better methods of killing animals than anything else which was being used, like hitting it on the head with a club. It was much more reliable as a method of killing the animal. And so this was the best that could be done at the time when it first started. And then it became a religious ritual. The first point to make is that when you cut the throat, that cutting does not anesthetize the animal. And what's the evidence for that? The first one is by talking to people who have had their throat cut, and there are a number of records. It's a very bad thing to happen, but there are records of it. And people report that it was extremely painful, universally. There is nobody who said, oh, it wasn't like an anesthetic. Secondly, you record from the brain, and you look at behavioral responses when the animal is having the throat cut, and it is very clear that consciousness continues, and it varies from one kind of animal to another, how long it continues. So the shortest is a sheep. It's about 20 seconds is the period when the animal is conscious and able to respond to the pain. And then it's about 120 seconds in chickens and about the same in cattle. It can be a little bit less, but it's the order of 2 minutes is frequent. With fish, which have the gills cut, it can be very much longer, especially if they are in cold water. So this, again, is all published material. And then another important point, because it is sometimes suggested that when the animal has the throat cut, that you immediately get the action of endogenous opioids, which are painkillers, naturally occurring painkillers. Well, there is no evidence at all of that. No evidence that you get endogenous opioids when the throat is cut. And another paper by the group, by Gibson and his co-authors, they recorded EEG when the throat was cut by a ventral neck incision. And the response, that is the electrical EEG response and the behavioral response, was exactly consistent with the cut causing severe pain. They also tried cutting the neck without cutting the blood vessel. There wasn't very much difference. It seems as though it's cutting the neck which causes the most pain. It's not actually cutting the blood vessel which causes the pain. That's not surprising in terms of where the pain receptors are. So there's no question at all that it is a very painful thing to do, to cut the neck of an animal so that it starts to bleed. It's a very large wound. It's a big shock to the animal, but it is extremely painful, and there is no natural anesthesia. If you stun the animal immediately that the neck is cut, or just before, then the captive bolt gun or the electrical stunning causes the EEG to be flattened and the animal is unconscious. So what we are concluding then is that when animals are stunned, they do not suffer, but the welfare of animals killed without prior stunning is very poor indeed for a period which varies according to the species, but it ranges between 20 seconds and 2 minutes. So that's the problem time that we're talking about. So as I mentioned earlier, stunning at the time of cutting the throat is already widely accepted by a lot of people. Many halal slaughterhouses are doing this in a number of countries, and so individual Muslims and Jews and groups or authorities of Muslims and Jews are accepting it, but not everybody is accepting it. Okay, the next important point, which is very relevant to what Alberto was saying and what came up with the questions. Is the animal still alive after stunning? Well, the answer to this is if the equipment is properly adjusted, yes, it is still alive after stunning. So the stunning method is not intended to kill the animal. So the stunning is either with electrical with the electrodes on the head, or one on the head and one on the body. If they are both on the head, then there is a greater control of the current which is flowing through the brain and stunning the animal. And what can be adjusted is the equipment itself has to be of a certain quality, and the current which is passed through the brain is something which is controllable. And all of this equipment should be set in such a way that the animal is stunned but not killed. So the intention is to stun it. The intention is not to kill it with electrical stunning. And the captive bolt gun, which is applied to the head, if you have a big enough bolt or enough power, then you kill it. But it is set in such a way that the animal is still alive. And the animal remains alive, and this means it could recover. All of these stunned animals could recover, but they don't recover because the throat is cut. And the evidence for this is, firstly, that they do recover. We know that there have been a lot of studies done in which different currents have been used for electrical stunning, and different captive bolt machinery has been used, and they find out how many animals recover. So 100% can recover if it's done properly. If you record from the brain, the EEG record after stunning, it is very clear because of the pattern that the animal is still alive and functioning, fully unconscious but functioning at the time that it is up to the point where the throat is cut. And then you get a change once the animal's throat has been cut. And the third point, which has been mentioned already, is that when the throat is cut, blood can be seen to be pumped out by the beating heart. So if the heart had stopped, then you wouldn't see the pulsing of the blood coming out. So there isn't any doubt that except in circumstances where the equipment is not properly adjusted, that the animal is still alive at the point when it is killed by having the throat cut. Another point concerns whether the blood is removed from the body when these methods of slaughter are used. And this is a point which is relevant in religious slaughter, because there is a concern, particularly by Jewish people, that if the blood is left in the body, it is not acceptable, it is not clean. So kosher meat is supposed to have the blood bled out of it. So what happens when you kill animals in these different ways? Well, the first thing is that when you cut the throat, most of the blood in the body drains out of the body, most of it, but not all of it. And this occurs in an animal which is conscious, an animal which is unconscious, and an animal which has recently been killed. You get almost exactly the same amount of blood coming out, proportion of blood coming out, whether the animal is conscious or unconscious or recently killed. The rate at which it comes out depends on the movement. So if an animal is conscious, it struggles and jumps around a great deal, and that means that blood comes out faster at first. But the time for most of the blood to come out, the amount which is going to come out, is not so different. But no animal is ever completely exsanguinated by any method of killing. So halal and shechita do not remove the blood from the body. They never can do that. There will always be some blood left in the body. And both the front end of the animal and the hind end of the animal still have some blood in them. There's not much difference between the front end and the hind end. There's a little bit, but not very much difference. So whereas you will appreciate that the present situation is that the hindquarters are often sold off separately after shechita, because there is a view that it's different in some way. Well, this is not scientifically sound. And the small amount of blood which is left in the body isn't something which causes disease problems. It is not carrying pathogens. It is not carrying anything which is harmful to the person consuming the meat. And so it is not unclean in any way in a scientific sense. The idea that it is unclean because some blood is left in it is not correct. If it is left for a long while, then there is variation in how quickly it decays. But that's not really a point nowadays, because everything is managed well enough in all of the methods. Let me say something about gas stunning. Gas stunning is carried out for some animals now, particularly pigs and poultry. And the handling which occurs before gas stunning is very significantly better for welfare, for pigs and for poultry, than the handling for electrical and captive bolt stunning. So gas stunning is a good thing for welfare in terms of the handling which occurs. If you stun with an inert gas, then the animal does not know that it is in the inert gas until it is unconscious. And almost all animals are the same here. There is little variation. There are one or two species which seem to detect inert gas for a little while and show some response. And then the other gas which is used is carbon dioxide. Carbon dioxide is very aversive, and it causes poor welfare in the time before the animal becomes unconscious. And that is something between 20 and 46, maybe 60 seconds. So that's carbon dioxide. Okay. If the duration that the animal is in the gas for stunning is carefully controlled, the gas-stunned animal is still alive and will recover. If instead of cutting the throat, you take it out and leave it in air, it will recover. And this again is very clearly documented with quite a lot of research. So stunning using gas, if the duration in the gas is not too long, is reversible, and the animal is definitely alive at the time the throat is cut. If you leave the animal in a gas for too long, then it will die. The animal will die if it's in argon, or if it's in carbon dioxide, or if it's in nitrogen, the animal will die. However, if the animal does die after being left too long, and so it was actually dead at the point that you cut the throat, bleeding out is just as effective. There isn't any difference in the bleeding out. So all of these methods then are ones which do work, and the animals can, it is not at all difficult to ensure that the animal is still alive at the time that the throat is cut. So if you do have stunning, if you have shikita or halal, where the stunning is allowed to occur close in time to the point where the blade is applied, then the animal will certainly still be alive. Okay, so I'm happy to answer any questions if you have any.
Well, thank you so much, Professor Broom, for showing this topic of slaughter without stunning from the animal's point of view. Reineke, are there questions?
Yes, Anja, there are several questions and also still some interventions. So everyone, please stay with us till the end of this very important meeting. Firstly, I would like to invite MEP Francesco Guerrera to take the floor and come in, as he has to leave a bit early.
Thank you very much, Heineken and Professor Donald. My question is very direct and very clear, because I didn't understand in your presentation. How many animals are slaughtered without stunning? And in this evidence that is there any evidence that animal welfare is ensured in these circumstances where they are not stunned? So two different questions. If you have the data, we would like to.
Right. So for the vast majority of animals in the whole of Europe, and in fact in much of the world, stunning is carried out. The stunning works, and the animal is made unconscious, instantly unconscious at the point of the stunning, and then it is killed by the throat being cut. So that is where stunning is being carried out. The only time that the animal is not unconscious is if the stunning method fails. But these stunning methods, it is in almost all slaughterhouses, I have to say almost because I only know about some, but certainly well-managed slaughterhouses, there are people checking that the stunning was carried out and it's worked. In other words, the animal is not showing signs of still being conscious. If the animal is still showing signs of being conscious, then it is stunned again. And this is something which is normal practice in slaughterhouses, that they are checking animals in case. Okay, that's the situation. That's not the religious slaughter. That's the normal procedure with stunning before the throat is cut. In a slaughterhouse for shikita or halal, then the normal procedure is that there is one common procedure is that there is no stunning at all. The animal goes up to the point where the throat is cut, and after the throat is cut, there will be this period of 20 to 120 seconds when the animal will be in extreme pain and distress. So that's what happens with religious slaughter. That's the normal thing that happens, except for those slaughterhouses which are allowing stunning close to the point of the cut, in which case it will just be, well, it might be a few seconds, but not much. So that's the current situation. I don't know what the numbers are, but the total number of halal and shikita is a small proportion of all killing in the EU, but it is a significant number. I mean, it's millions of animals which are being killed by halal and shikita. As I mentioned earlier, in some of those cases, there is no stunning at all. Did that answer your question?
Thank you,
Yes,
Professor Broom. And just to add, Francesca mentioned in the chat box that indeed at the moment there's no mandatory and harmonized data collection of the animals being slaughtered without stunning at this moment. So consumers don't really know what they are buying, and this is really an omission apart from the source of the problem, of course. So I would like to invite Tilly Metz to come in and ask a question.
Yes, good afternoon. Unfortunately, I also have to leave in a few seconds already, but it was very interesting, and thank you again for this very good organization and the presentation. I'm looking forward also to have the presentation of Professor Alemanno afterwards, and I'm surely going to write to him with my question. But now a question to Professor Broom, where I was lucky that I could follow the presentation. How do you explain, Professor, that you have the knowledge and you say that we have the same amount of blood coming out if the animal is conscious, unconscious, and recently dead? How is it possible that we still have then these methods of halal and kosher killing of the animals, knowing, having that knowledge and your scientific studies about that? How is it possible that it doesn't come into the communities and so on and so forth, in order to say you don't need to have to do that? It doesn't make no difference concerning the exsanguination, if it's conscious or unconscious or recently dead. How do you explain that that this knowledge doesn't succeed to change the attitude? Thanks a lot.
I'm afraid that it is the case that this one has been an idea which has been around for a long time, that there is a difference between a conscious and an unconscious animal. It could be because, as I mentioned, if an animal is very active, then the blood comes out faster than if the animal is less active. So at the beginning of the period, after the animal has had the throat cut, there is difference in the rate at which the blood comes out. And that has been observed for thousands of years. And as a consequence, people had the idea, well, the blood doesn't come out properly if the animal is stunned. As soon as you do scientific studies on it, it's quite clear that the time for the blood to come out, as far as most of it is going to come, is not in fact different. It may be faster at the beginning, but the time by the end of the period, there isn't much difference. So by the time the animal's actually unconscious, there is if the animal is stunned, stunned or not stunned, then there isn't any difference in the amount of blood that comes out of the body. And I think it is scientifically demonstrated, but it is not comfortable for some people to accept that it's true.
Thank you very much for this explanation. Thank you.
Yeah, and it's indeed also very good for us to have this information. Moving to the next MEP who would like to come in, MEP Virginie. We know you would like to speak in French, and we provide translation in English for those who are not able to follow.
Okay, thank you. Vous m'entendez?
Oui, très bien. Oui.
Écoutez, merci beaucoup. C'était très intéressant, les deux interventions. Moi, là, juste quand j'ai écouté le docteur Boom, j'ai plus du tout envie de manger de viande. Ça fait peur. Et en fait, je vous remercie beaucoup d'avoir mis ce sujet à l'ordre du jour. Nous avons cru avoir gagné le début de la bataille, mais manifestement, non. Et pour le plus grand malheur des animaux, en fait. Donc, je vous remercie effectivement d'avoir mis ce sujet et de me permettre de parler, parce que c'est un sujet qui m'intéresse beaucoup. Une question a été posée de savoir combien d'animaux étaient tués. Moi, je sais qu'en France, il y a 61% d'abattage sans étourdissement de la viande, pour des raisons surtout économiques. On le sait tous, la moitié, plus de 80% des abattoirs français pratiquent l'abattage sans étourdissement. Et à côté de ça, nous n'avons que 6% de consommateurs. Ce qu'il veut dire, et c'est toute la problématique, en dehors de l'aspect religieux, technique et juridique, puisque c'est aussi un argument qui a été proposé auprès de la CJCE. Moi, aujourd'hui, je m'interroge et je souhaite que cette question soit reprise par l'intergroupe via une résolution, via des conférences, via des campagnes de sensibilisation. Moi, en tant que consommateur, je veux savoir quelle viande j'achète et je mange. Et aujourd'hui, la commission que j'ai interrogée me dit que ce n'est pas obligatoire. Donc, il y a cette problématique en dehors du fait que l'abattage sans étourdissement est pour moi une atrocité insupportable envers les animaux, au même titre, je suis désolée de dire, comme l'excision et la lapidation, mais ça c'est un autre sujet. je considère qu'on doit protéger, on doit informer, on doit demander aujourd'hui, en 2020, un étiquetage sur le mode d'abattage que la viande qu'on achète a subi. Voilà, donc je déborde un peu sur le sujet. J'ai vraiment apprécié toutes ces contributions et je pense que nous, en tant qu'on a cette charge, nous, députés, travailler avec vous pour pouvoir aller plus loin dans la réflexion et je vous remercie beaucoup de m'avoir permis de m'exprimer à ce sujet.
Pour moi, c'est la même chose. Ce n'est pas acceptable pour moi qu'il y a viande pas étourdie, effectivement, et je mange cette viande. Ce n'est pas acceptable. Et je crois que beaucoup des personnes, beaucoup du monde, ce n'est pas acceptable, ça. C'est une difficulté pour tout.
Tout à fait.
Many thanks, MEP Virginie and Professor Broom, for raising this issue. I think the good news is that in the Advocate General's opinion, there is a reference to better transparency and better labeling. But clearly, at the moment, we are mainly looking at the core of the problem, which is allowing member states to introduce stricter measures. But the information to consumers is definitely a serious issue too. Before we will invite another guest, namely the Federation of Veterinarians in Europe, to make a short intervention, I would like to ask Petras Austrevicius to come in again because he has another question to Professor Broom, please.
Thank you, Enrique. Thank you, Honorable Professor Broom. You used a lot of scientific evidence and well-grounded arguments, legal as well as animal welfare-based arguments. I mean, to what extent those arguments have been passed, heard, and admitted by the religious communities, mainly Jewish and Muslim, in order to have a good exchange and proving a real, I would say, two-way dialogue with those communities in general. I mean, do you have any feedback from any of those debates you had, or probably somebody had it? Thank you.
Yes, I have been involved in quite a lot of debates like that. So I think the first one was in 1992 when I was the chairman of the EU Scientific Veterinary Committee, and we had a discussion about exactly this subject with the board of jury of the European Union. And I've subsequently been in several meetings with people. Now, at the beginning, one of the reasons why I made the points that I did was because of what are the arguments of people who are trying to defend religious slaughter. As I said, at the beginning, it was a very good way to kill animals. But now that we have the possibility to make animals unconscious at the point that their throat is cut, then my personal view is that we should do that. But there has been the view that the blood doesn't come out, or the animal could be dead, and that doesn't fit. That is not acceptable to the religious authorities. It must be alive when the throat is cut, and this is a sensible idea, because you don't want to have an animal which has been dead for a long time and cut the throat, and then it doesn't bleed out very well. And so because it's been dead for a long period, and it's not good for public health, of course. But all of this argument doesn't work for the modern situation where the animal is being stunned only a very short time before the throat is cut. So but these are the central issues which have been raised, and also the idea that when the throat is cut, the animal, it is an anesthetic device to cut the throat. And actually, when you observe the behavior of the animal, when the throat is cut, there's a big shock response. And sometimes the animal does not move very much. And it happens to humans who have the throat cut also. When there is a really big injury, especially one which interferes with bleeding in a dangerous place and possibly with breathing also, the behavioral response is not to move very much. And so they had the idea, well, the animal is anesthetized by the cut. Actually, when you measure it, there is no anesthesia of any kind because of the cut. So there have been discussions over quite a long time, and gradually the scientific evidence has had to be accepted by people who are in the, and then if the scientific evidence is accepted, then you have to fall back on, well, it is our tradition and you are not allowed to interfere with our tradition. So these are the sort of arguments which have come up. Maybe other people have listened to other arguments.
Thank you, Professor Broom, for this explanation. And we shouldn't forget that there are large religious communities that are accepting the alternatives across the world. Right. I would like to invite another important guest, the Vice President of FVE, the Federation for Veterinarians in Europe, Turil Mozang, to give a short presentation on the position of the FVE.
Thank you very much. I was told that someone would show the presentation for me at your site. Is that correct?
Yeah, and that's happening as we speak. Can you see your own presentation?
Yes, thank you so much. Thank you. Thank you for having me here in this very important issue, slaughter without stunning and veterinary concerns and labeling. And I would also say thank you so much to Professor Broom and to Professor Alemanno that were presenting really interesting and informative presentations. As you said, I'm a vice president and a veterinarian and representing FVE. And FVE is the Federation of Veterinarians of Europe, and we are having 47 national associations from 39 European countries and also have 4 sections, as you can see. We represent over 300,000 veterinarians, which has a lot of skills and competence in these areas and other areas. And our mission in FVE is to enhance animal health, animal welfare, public health, and protect the environment by promoting the veterinarian profession. And in, next slide please, FVE in 2002 unanimously adopted by all FVE member organizations this statement, and it still stands. And it says, FVE is of the opinion that the practice of slaughtering animals without prior stunning is unacceptable under any circumstances. And of course, what we think about that is that this is very unacceptable animal welfare because of the stress and the pain. Next slide, please. And why is stunning so important? I think we got a lot of interesting thoughts about that and some facts about that in the other presentations. But if you look at the figure here, one with stunning and one without stunning, then you see the conscious period is quite different when you have the stunning compared to the other one without stunning. And in the unconscious period, when it's leading to death, the animal is not feeling pain at all and are not conscious. But on the other one, without stunning, there you can see that the animals absolutely are conscious and are not unconscious before the death is there. And this is the huge difference from the animal welfare by slaughtering with or without stunning. And, you know, stress in an animal, you can never avoid that when you're going to the slaughterhouse or you're going to slaughter the animal. And the stress depends on very many factors, but one of them is the situation at the slaughterhouse, of course. And because the animal is conscious, they can feel the pain all the time, and they feel the pain before they bleed out when they're not doing the stunning in front. Next, please. Thank you. You can see here a figure that if the slaughtering are done under optimal practical conditions, then you can see that if the animal is not stunned, it's over 60 minutes for 8% of the cattle. It took longer than 60 minutes. And in the maximum, it took 5 minutes. And this is, of course, way too long to wait for the death. And during this period, it is not a good condition for animal welfare. Next, please. There is a very important point about this subject, that a lot more animals are slaughtered without stunning than the market actually require. And as we can see, it is practical and economical reasons. But that should not be the PowerPoint. The PowerPoint should be to treat animals in a well and nice way. And also you can think about that if the animals are treated in a good way, of course the meat will be less stressed for the consumers afterwards. Another point is that this meat will go to the market without labeling. And one of the professors were also talking about that. And the consumer do not know about this procedure. And the consumer absolutely then have no opportunity to choose between those two meat products. And as we know, the society now is very much aware of animal welfare and should have the opportunity to do so. We also know that the advocate in general have concluded that this is not acceptable. We need labeling for this type of meat. Thank you. And the next slide, please. So the conclusions from the FVE site is that slaughtering without prior stunning should be prohibited to avoid unnecessary suffering. And the EU should allow member states to put in place more stringent welfare conditions. But while it's still performed, it should be done only in certain requirements and registered slaughterhouses. And we also need to bring post-cut or reversible stunning to be considered. And we also need to only accept this at this point, when it's done, only for market designated, not as it is like today, that many more animals get slaughtered without stunning, even if the market doesn't require it. And consumers, of course, need to know and has the rights to know, that's a key point also, that all meat from animals slaughtered without stunning should be labeled. Thank you very much for the attention, and thank you for taking up this very important subject.
And thank you, Madam Moseng, for this very interesting presentation, and also for the support from the veterinarians who were very best placed also to know what's going on. And also thanks to Nancy for their helpful comments in the chat box. We have one last short intervention before we will open up for some final questions. We would like to hear from Elke Drijsma from the Dutch Party for the Animals, what's happening in the Netherlands, because we know that the Netherlands has been working also on a legislative proposal to prohibit slaughter without stunning. Nelleke, would you be able to share your views on this with us?
Hi, thank you. I hadn't really prepared for this anymore, but I can tell you briefly what we're up to. We were, of course, very disappointed by the advice of the Advocate General, but we're still proceeding with our ban on slaughter without stunning. So we're just looking for some information. Today was very helpful for that, from Professor Alemano, sorry. Yeah.
So would you agree with the legal analysis as was presented? And is this also along the lines as you have argued the case in the Netherlands?
Yes, well, we're still in the process of the discussion here. But yes, we share his analysis. Yeah, we're still looking at it. I'm sorry.
Okay, thanks so much, Elke, to share that with us. Before we close this meeting, who else would like to come in? Also non-MEPs, would you like to make a final statement or ask our experts a final question? Feel free to unmute yourself and come in. All right, then I think that everyone was very impressed, Anja, by the enormous amount of legal and scientific evidence we have been receiving today. I think we have a very strong case to plead for prohibition of slaughter without stunning, whilst respecting also certain religious preferences. So we are looking forward, of course, what will happen over the coming month, and we encourage all MEPs to also do their bit and see, how they can speak out themselves individually. So back to you, Anja, to share with us the key conclusions of this meeting.
Well, thank you, Reineke. Yes. It was indeed a lot of information to process, but thank you again for all speakers and panelists for your valuable contributions. And even though the Intergroup is an unofficial body of the European Parliament, it is part of the EU institutions and therefore not in a position to express its view to the European Court of Justice. However, it would be helpful if you as individual MEPs could address this yourself by reiterating through your own channels the member states' rightfulness to adopt national rules to ensure more extensive protection of animals at the time of killing than those foreseen by law. And this would be in line with Article 26.2 and Recital 18 of the EU regulation on protection of animals at the time of killing. And because I think the most important thing here is that we should not forget that the religion of its slaughter does not make any difference to the animal. So before I close this meeting, I would like to invite you all for our next session of our intergroup, which will take place on Thursday, the 19th of November from 10 till 11:30. And it will focus on what needs to change for broiler chickens in the EU. And as a follow-up to our adopted resolution in 2018, which was an overwhelming majority who supported this. The meeting will also include a virtual visit to a broiler farm. So I hope to see you all there in November. And for now, take care of yourself and others and have a good evening. Bye.